Good evening and welcome to the January 30th, 2024 Hempstead Town Board meeting. Supervisor Clavin is a little under the weather today, I think. He's not able to be here. So I am honored to fill in this evening in his place. As most of you know, I'm Dorothy Gooseby, the Deputy Supervisor. Madam Clerk, will you please call the roll?
Yes. Councilman Carini.
Here.
Councilman Dunn. Oh, right. Deputy Supervisor Gooseby.
Here.
Councilwoman Miller.
Here.
Councilman Muscarella.
Here.
Councilwoman Ryder.
Here.
Councilman Muscarella, would you please lead us in the Pledge of Allegiance?
Please stand, hand over your heart. Repeat after me. I pledge allegiance
to the flag of the United States of America, for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Madam Clerk, will you please call the public hearing?
Yes, we have a public hearing pursuant to New York Eminent Domain Procedure Law, Article 2, regarding 434 Hempstead Turnpike in West Hempstead.
Okay, that's all I see. This evening, the Town Board will take testimony, and they'll hear presentations regarding the town's possible use of eminent domain to acquire certain property known as 434 Hempstead Turnpike, West Hempstead, improved with a motel known as the Capri Motor Inn. I will now ask the Honorable Anthony Marino, retired New York State Supreme Court Justice and the town's special hearing officer appointed by this board for this hearing, to explain the consequences for tonight's hearing.
Thank you, Deputy Supervisor Gooseby. So I say hello, good evening to everyone. The purpose of the meeting tonight is basically limited to the eminent domain circumstance relative to the Capri Motor Inn, and we're going to proceed in a relatively uncomplicated fashion. We're going to begin with a presentation by the special counsel to the town. It's the firm of Sir Tillman Ballin, Adler and Hyman, and tonight Alan Hyman from that firm is going to be here and making a presentation. At the end of the special counsel's presentation, the owner of the property, and may I ask, is the owner present this evening? And if so, okay. Good evening, counsel. After Mr. Hyman and his staff makes their presentation, I'm going to ask you if you would like an opportunity as well to make a presentation. Do you expect that you're going to be doing that? Yes. Okay. So we'll be getting to you a little bit later in the evening. After the attorneys finish their presentations, then the public will have an opportunity as well to voice their thoughts with regard to this eminent domain proceeding. So the difference between the attorneys and the public is only the difference in terms of time. The public in general, I'm told that at the town board, and confirmed that that's the rule, are limited to 3 minutes if anyone wants to speak. But we'll deal with that a little bit later. At this time, I'd like to call upon Alan Hyman and ask him if he's ready to make a presentation.
Thank you, Justice Morano. Deputy Supervisor Gooseby, members of the town board, my name is Alan Hyman, as a judge introduced me, and I'm special counsel to the town board, I guess, for purposes of this hearing this evening. So, Tonight's hearing is being held pursuant to Section 203 of the New York State Eminent Domain Procedure Law. In order to outline the purpose, proposed location, or alternative locations of a public project taking place at 434 Hempstead Turnpike, West Hempstead, New York, it's also described on the Nassau County Land and Tax Map as Section 33, Block 614, lots 26 through 28 and 71. The hearing is also being called for the purpose of considering any other pertinent information, such as a more detailed description of the property, which you're going to hear later on in the hearing. As Judge Morano indicated, any person in attendance shall be given a reasonable opportunity to present an oral or written statement and to submit other documentation if necessary. A record of this hearing is being kept, including written statements submitted, which can be submitted and made part of the record, and the entire record will be made available to the public for examination without cost during normal business hours at the office of the county clerk and the town's website. The purpose of the hearing is to present and gather information related to the potential acquisition of property located at 434 Hempstead Turnpike in West Hempstead. The issues before the board tonight are: 1, the public use, benefit, or purpose to be served by the proposed project; 2, the approximate location for the proposed project and the reasons for the selection of that location; and 3, the general effect of the proposed project on the environment and residents of the locality. Such other factors as the town considers relevant will also be considered. With respect to the location of the property, there was no alternate location that needed to be discovered or discussed, because we're dealing with the appropriation of the property known as the Capri Motor Inn. So there was no other location that needs to be discussed, and so we're only dealing with the issue substantially the public use or benefit for the project and the general effect that this project will have on the environment. Those are the two main issues tonight. The board will hear from various speakers, including the property owner and members of the public, regarding the public purpose, the location, and the general effect of the project on the environment. The hearing will be kept open for a period of 30 days until March 1 of 2024. During that period, the board will accept written comments from anyone who wishes to submit them. All written comments should be mailed to the town attorney's office at Town Hall, 1 Washington Street, Hempstead, New York, or emailed to johnmack@hempsteadny.gov. That's the town attorney's address online. After the 30-day period has elapsed, Judge Morano will review the minutes of the hearing, the record adduced at this hearing, and consider all written comments submitted. Judge Morano will then make his recommendation to the town board, and based on Judge Morano's recommendation, the record, the written comments from the public, the board will vote on whether to take any action to acquire the property that is the subject of this hearing. The board will consider the adoption of determinations and findings and publish same in accordance with the requirements of Section 204 of the eminent domain procedure law. The town's legal notice requirements relative to the public hearing, this hearing, have been met by publishing the public notice in 5 successive issues of Newsday between Monday, January 8th and Friday, January 12th, and by mailing the public notice to the property owner and all adjacent property owners by certified mail. All documents, the record and written comments submitted to the board at tonight's hearing will be available on the town's website and the Nassau County Clerk after the close of the hearing on March 1 of 2024. A transcribed record of tonight's hearing will be available on the town's website, and also it will be available at the Nassau County Clerk's office. So, I have provided you with a binder which contains all of the material, written material, that we would like to submit for the record. And you will notice that the binder contains tabs and a table of contents. So what I would like to do at this point is to very quickly go through the contents of the binder and ask that the contents of the binder be marked into the record of this hearing. So the first, in tab number 1, under A, I've enclosed a copy of General Municipal Law Section 74, which is the enabling statute. It is Section 74, and it deals with the condemnation of real property. This is part of the General Municipal Law. It simply provides that a municipal corporation authorized by law to take and hold real property for the uses and purposes of the corporation may, if it is unable to agree with the owners for the purchase thereof, acquire title to such property by condemnation. So that is the enabling law that provides simply that the town of Hempstead has the power of eminent domain. Now, the Constitution of the United States, in amendment, the Fifth Amendment to the Constitution, which is applicable to the states by virtue of the 14th Amendment, provides that property cannot be taken except for a public use or a public purpose without paying just compensation. And so, in a case like this, the eminent domain procedure law governs the procedure by which private property can be acquired for a public purpose. And I have provided those sections of the eminent domain procedure law in the binder, and they can be found in tab 1A through E. So I've also provided earlier decisions of the town board of the town of Hempstead under tab 2, which was a resolution by which the town board declared the subject property to be a public nuisance. That's under paragraph 2A. And under paragraph B, there is a provision here there is a reference here to a notice that was given authorizing the town attorney to seek a condemnation of the Capri Motor Inn property. I've provided information with regard in tab 3 to the property data card, which indicates the data that is on file in the Nassau County Department of Assessment. And I've also provided tax maps, which indicate the subject property as well as adjacent properties with information for both. We've provided in tab 4 the notice for this public hearing with supporting documentation, and we have under sub-tab A the notice of public hearing, the affidavits of service of notice on the property owner and adjacent property owners. We have copies of certified return receipts, the affidavit of publication from Newsday, and the Newsday proof of publication. Now, the issue with respect to notice, the statute requires that notice of these public hearings be given by certified mail return receipt requested, so the record will indicate that notice was given for this public hearing by certified mail return receipt requested. Tab 5 contains a copy of the taking map, which is basically a survey of the Capri Motor Inn property. And tab 6 are the minutes from a town board meeting that took place on August 31st of 2023, which was continued a few days afterwards. I have to get you the exact date on that, which I will. The exhibits that were entered into that meeting are also indicated on 7A through H, and we've also included in tab 8 the minutes from the town board meeting on September 6th of 2023, which I believe was the continued meeting from August 31st of 2023. You will also find in tab 9 a report by Cash and Associates, which was an engineering report that was made available to the town board at the time that the town conducted that hearing. It goes into a lot of detail about the condition of the property at the time that that report was made. Now, under tab 10 and 11 are the Nelson and Pope reports that you will hear tonight from John Ellsworth, and the tab 10 is the report on the public purpose for the subject property, and tab 11 is the environmental assessment form that was prepared by Nelson and Pope, which goes to the issue of the effect of the proposed condemnation of this property on the environment. I've included John Ellsworth's resume. He will be testifying this evening. And we have also included Nassau County Police Department reports, which were their incident reports, showing what occurred there. There were numerous, there was a tremendous amount of criminal activity that took place during the period from August 1 of 2022 through August 31 of 2023. And we have also included letters in support of the condemnation of the Capri Motor Inn property and letters in favor of closing the motel. We've also included a statement in support of reopening the Capri Motel from an individual, Saul Brooks. So that's basically the record, and what I wanted to say was that the real issue in this case that the town board needs to really determine is whether or not this property has become a public nuisance. And you're going to hear testimony from John Ellsworth on that issue. And because there has been so much police activity and there have been so many incidents of criminal conduct at this motel for an extended period of time, it has resulted in a terrible impact which affects the health, safety, and welfare of the residents of this community. And they have been really the subject, and it's terrible to say, but that community has been the subject of blight. They have been blighted by all of this criminal conduct. We have letters from residents who say they can't walk around this beautiful community without fear of being accosted by people who are resident in the motel or who are there for criminal activity. You will see when you go through the incident reports that murders have taken place at this hotel, at this motel, and in addition to murders, there have been major felonies involving drug sales, prostitution, assaults, and so it has become not just a problem, but it has become a source of terrible fear on the part of people who live there. And so what the town board is being requested to do is to find and determine that as a result of this criminal activity that has been taking place, and as a result of this motel being literally unfit for human habitation, which you can see from the reports, the engineering reports that were done, and it's part of the record now, I think that you will find that this has become, and condemnation of this property has to be done in order to abate what has become a major nuisance, a major public nuisance. And so I'm going to let the record speak for itself, and I'd like to call as a witness John Ellsworth, who was an engineer with the with the firm of Nelson and Pope, and he is going to address the board and give his report on the issue of public purpose and on the issue of the impact that this condemnation might have on the environment. So I give you John Ellsworth. Thank you.
Mr. Hyman, is the information that your witness is going to provide within the record itself as well?
Yes, it is, and I had mentioned that, but I will give it to you again, Judge.
No, you need not, but it's there.
I have 10 and 11 in your binder.
Thank you. Mr. Ellsworth?
Good evening, Judge Morano, Adams Deputy Supervisor, member of the board, John Ellsworth, Nelson, Pope, and Voorhees, 70 Access Road in Melville. I just want to correct one small thing Mr. Hyman said. Agree with everything else. I'm not an engineer. My profession is I'm an environmental planner, senior associate with Nelson, Pope, and Voorhees.
Can someone check the mic, see if it's on?
How's that? Better?
No.
No? Will work for you. All right, I'll try to speak more loudly. Nelson Pope and Voorhees was asked by the town to analyze the public use, benefit, or purpose that would be served by the proposed land acquisition via eminent domain. We prepared a report dated January 25th, 2024, with our observations. I understand that the documents are on the PowerPoint. Can we get to the cover of the report, the first page of the report? Who has the clicker? All right.
Well, just give us a verbal representation.
As Mr. Hyman said, the report has been submitted into the record as part of the book of exhibits. Today's testimony provides a summary of our report. The report should be consulted for the full details of the investigation and analysis supporting our findings and conclusions. As shown in the report, the proposed acquisition via eminent domain would serve a public purpose and benefit by abating a public nuisance, as Mr. Hyman had mentioned, that has significantly adversely impacted the community in the area of the subject property. Our investigation included, but was not limited to, a review of the Cashin report that Mr. Hyman mentioned, dated August 18, 2023, review of the transcript and exhibits for the public hearing conducted by the town board on August 31st and September 26th, 2023, review of aerial photographs and maps and other relevant information sources. Thank you. Inspection of the site and surrounding area on December 8th, 2023. All right. Who's got, is there a clicker that I can go through? Okay. Go to the end of the report. There's a couple of figures. That one, up, back. One more back. Okay, one forward. Next page. Okay. This figure shows the location of the subject property. It's on the north side of Hempstead Turnpike, within the Hempstead Turnpike commercial corridor. Next page. This is the aerial photo that was up the whole time Mr. Hyman was speaking. A brief description of the subject property. It's about 1 1/3 acre in size. It's, as you can see, it's L-shaped. It's almost completely paved. There's a little bit of landscaping in the front. It contains 3 buildings which had operated as a motel with approximately 80 resident rooms. The south building, the little building at the front of the property, 1-story building with basement. It primarily served as the main lobby area and management office for the motel. The north building on the leg of the L at the back of the property, it's 1-story building with basement, and it contained rooms for the residents and associated features. And the east building to the right in the aerial photo is a 2-story building with a basement utility room. It also contained individual rooms for residents and associated features. The existing conditions, and this, again, is the summary of what's in the report regarding the interior of the building. This is from the August 2023 Cashin report. It documents conditions in the building interiors based on their inspection on August 7, 2023. Points to observations of numerous hazardous, unsafe, and/or unsanitary conditions supporting the conclusion that the buildings are in violation of Chapter 90 of the Town Code. These findings were the basis of the motel being closed for a period of up to 1 year pursuant to the dangerous buildings provisions in Chapter 90 of the Town Code. Can you go to the next page, please? This is a land use map within a 1/2 mile radius that was included in our report. The key feature evident in this map is the preponderance of the yellow in that figure, and that's residential use. Like the majority of the town of Hempstead, the area around the subject property primarily is a residential community, with commercial and other supporting uses concentrated along the main roadways. It's also should be noted that in the residential neighborhood areas, there are typically are schools, and there are 2 schools in this area. The information presented in our report regarding the site use and activities is based on documents that have been compiled into the record in connection with the prior proceedings regarding the subject property. And they include the transcript of the previously mentioned town board hearings on August 31st and 26th, September 26, 2023. It included testimony by members of the local community, Nassau County Police Department, and representatives of the motel. Also, the documents we reviewed included the exhibits to that hearing, such as correspondence from members of the community, the police department case reports for individual incidents, which prompted a police response to the property over a 2-year period, and a written statement submitted on behalf of the motel owner-operator. There was also a petition with more than 800 signatures supporting closure of the motel, and of those signatures, more than 250 were identified as being residents of West Hempstead, and there were also many other signatures from the surrounding communities. As detailed in our report, with direct citations from the hearing testimony and correspondence, prior to the closure of the motel, residents in the vicinity experienced significant adverse impacts to their community character and quality of life due to persistent illegal and antisocial behavior associated with the motel. This included criminal activity, as per the anecdotal statements from the residents, along with the police department records, and other incidents that are antithetical to civil society, such as vagrancy, panhandling, and other aggressive behavior by the residents of the motel and people visiting the motel. I'll provide a small sampling of a much larger citation in our report to give a sense of what the neighbors were dealing with when the motel was in operation. And these are direct quotes from the hearing and the correspondence that was submitted. We have faced public safety issues, as well as being forced to endure having to witness prostitution, vagrancy, loitering, illicit substance abuse, and sales. We have had our share of crime waves on our blocks, burglaries and attempted burglaries committed by the residents of the motel, assaults occurring in the middle of our streets, drug transactions, etc. We constantly have people on cell phones pacing up and down our streets on foot to be ultimately met by a car operated by a dealer. The drug transaction is made, the car drives away, and the satisfied customer sprints back to the Capri Motel parking lot. I have often arrived home late at night. I have often arrived home late in the evening and have had to remain in my car because residents of the hotel are wandering down the block, waiting until they have passed to feel safe enough to attempt to enter my residence. And forget about walking my dog at night. There is zero sense of security as the evening gets later. This establishment has not brought any positive benefits to our community. The Capri Motel has long been a disturbing and unsavory presence in our family-oriented community. My teenage/20s kids can't even go to the gas station without being afraid. And the next one is particularly caught my eye. My children were never allowed the whole time growing up to play outside by themselves in the front of the house. They had to stay in the back. That is no way for a family to grow up. We stopped getting our fuel at Speedway, which is the gas station across the street from the motel. We got tired of being harassed by people begging for money, and sometimes they actually get nasty and violent. And then the last one that I included just excerpts of what was in the hearing transcript. Our residents should not have to accept and put up with the drug sales, prostitution, and drain on our police department and emergency services. The Nassau County Police Department records include a 26-page spreadsheet listing individual incidents which prompted a police response at the subject property over a 2-year period. These incidents included, and I'm just going to list them once, but for a lot of them there were multiple instances: criminal possession of a controlled substance, assault, weapon possession, homicide, prostitution, attempted murder, criminal mischief, criminal contempt, larceny, burglary, disorderly conduct, harassment, domestic incident, possession of a forged instrument, and unlawful surveillance. The owner-operator of the motel took the opportunity during the hearing to submit a statement into the record on its behalf. Certain aspects of this statement are noteworthy. This is a quote from their statement. "The motel does its best to police its guests, but we cannot be held responsible for what a particular person may do in his room during his stay." This statement is particularly problematic because regardless of whether the owner/operator was responsible for the numerous illicit and problematic incidents that occurred under its watch on and around its premises, it's evident that the motel was serving as an accommodating venue for these incidents. The dismissive attitude expressed in this statement does not suggest that there is a reasonable prospect that the motel, if reopened, would become a good neighbor, which enriches the community character and advances the quality of life for the community. The statement goes on to claim that the motel is, and again quote, located in one of the less scenic areas on Hempstead Turnpike. Within a short walk from the motel, there are at least 3 bars and liquor stores, plus a gas station across the street, and several other vacant business properties. This seems to suggest that the owner-operator's opinion that the community has undesirable characteristics which are unrelated to the motel, in an apparent effort to downplay the motel's impact on the community. However, bars, liquor stores, and gas stations are common permitted uses that occur in virtually every community within the town and the wider region. And commercial areas throughout Long Island have vacancies, a condition that has been exacerbated by the effects of the COVID-19 pandemic. Furthermore, in contrast to the motel, as discussed throughout our report, these conditions are not inherently harmful to the local residents. The statement on behalf of the motel owner-operator also failed to acknowledge that the 1/2-mile radius around the subject property contains several uses, including a number serving children, which are highly sensitive to the criminal activities and other problems that have been associated with the motel. 6 such sensitive sites are identified on the land use map, and you can see them barely there. They're all labeled there. There are 2 elementary schools, 3 parks and recreation facilities. Again, all of these facilities serve children, and even a nursery school. It's also important to point out that the proposed land acquisition by eminent domain is consistent with the town's comprehensive plan as embodied in the town code. The town board took action pursuant to Chapter 91 of the town code to declare the subject property a public nuisance. However, this is only a temporary measure for up to 1 year. Further action by the town to acquire the subject property represents the logical next step to ensure that the egregious conditions and circumstances which served as the basis for the nuisance determination and temporary closure of the motel are permanently and irrevocably terminated. The need for this additional action by the town is evident given the lack of meaningful, substantive indication that the motel owner/operator has the capacity, desire, or inclination to implement the necessary remedial action. The Cashin report, that was the report that was done on the physical inspection of the property that led to its closure, identifies numerous physical deficiencies that represent hazardous, unsafe, and/or unsanitary conditions. On the basis of these findings, the town closed the motel, thereby eliminating exposure of on-site residents to these potentially harmful conditions. Although it may be possible for the physical deficiencies identified in the Cashin report to be corrected, this would not address the broader issue relating to the unwholesome and criminal behavior that has been allowed to flourish at the motel, to the detriment of the motel residents, which the owners/operators have failed to rectify. It's also well established that the problems at the motel permeated the surrounding community. Numerous local residents testified to harrowing experience, some of which I quoted a little earlier, involving the activities of motel patrons that significantly diminished the quality of life and disrupted the community character, as supported by statistics provided by the Nassau County Police Department, documenting almost 600 incidents involving police response related to the motel over the recent 2-year period. The conditions at the motel clearly have detracted from the high-quality suburban lifestyle for which the town of Hempstead is widely and rightly recognized. The operation of the motel has deprived the surrounding community of this benefit, which accrues to the communities in other areas of the town that are not similarly burdened by a disruptive land use like the motel. The motel is starkly disparate from the other local non-residential uses in the area, which includes a range of uses serving local residents, such as commercial facilities offering goods and services, elementary schools, governmental and religious facilities, and parks and recreational facilities. Not only does the motel not serve the residents of West Hempstead, but in fact, this facility has had a significant undesirable effect on the community character and quality of life. Based on the conditions at the subject property, the permanent discontinuation of the motel use through the town's acquisition via eminent domain will provide a significant and lasting community character upgrade to the site, enhancing the quality of life for the residents of the area to correspond more closely to what residents experience in other parts of the town. The action already taken by the town establishing that the motel is a public nuisance provides the community with a temporary reprieve from the problems that have been associated with the operation of this facility. The town's acquisition of the subject property will prevent the future reactivation of the motel use, thereby precluding recurrence of the associated negative impacts to the community that this use has caused in the past. So briefly, the conclusions in our report. The record includes personal testimony and written submissions from the local community, Nassau County Police Department, and others, which provides an extensive and compelling narrative of the adverse community impacts that have resulted from the operation of the motel, including a steady stream of serious criminal activity and other behavior that is antithetical to civil society. The problems associated with the behavior of many motel residents have adversely impacted other law-abiding residents of the motel. The problems associated with the motel have infiltrated the surrounding area and has deprived residents of the outstanding community character and high quality of life enjoyed in other areas of the town that are not similarly burdened by a deleterious land use like the motel. The proposed action will have the public benefit of advancing the provisions of the town code, which represent the comprehensive plan for the town of Hempstead, by protecting the public health, safety, and general welfare of its citizens. I'm up to 5 now. The proposed action will have the public benefit of precluding reactivation of the motel, thereby permanently eliminating the potential recurrence of conditions that are unsuitable for human habitation by on-site residents. Due to the absence of evidence that a reopened motel would be transformed into a good neighbor by rectifying the well-documented problems of the past, the proposed action will have the benefit of avoiding reliance on an uncooperative and/or ineffectual owner/operator to address these problems in a manner that creates and maintains a wholesome setting that is conducive to the health, safety, and welfare of community residents, both on the site and in the surrounding area. And seventh, the proposed action will have the public benefit of precluding reactivation of the motel, thereby permanently eliminating recurrence of the problems of the past and enhancing local community character and quality of life, which has been severely and adversely affected by the prior operation of the motel. And that's a summary of the report on the public purpose, need, and benefit. If I can get on the screen the EAF, which is a separate document. That's it. Nelson Pope and Voorhees also prepared Part 1 of a full environmental assessment form, EAF, pursuant to the requirements of the State Environmental Quality Review Act, SECRA. This 13-page form provides information regarding the subject property and the proposed action to assist the town in determining whether there is a potential for significant adverse environmental impacts. Based on the information contained in the EAF and our report, which I've just summarized, on the project purpose, benefit, and need, we also completed an analysis examining the full range of environmental parameters under SECRA, State Environmental Quality Review Act, as summarized in the memorandum that we prepared as an attachment to the EAF. If you can go to page 15 maybe. No, keep going. Go, you know what, go to the end and then back up is probably the easiest. Of the document that you were just in. Any other, that's it, thank you. All right, so this is the our analysis of the potential environmental impacts. The pending action by the town board entailing transfer of the land title for the subject property from the current owner to the town via eminent domain does not involve any physical alteration of the site and therefore will not result in any direct environmental impact, positive or negative. For some environmental parameters, the proposed land acquisition will have a long-term benefit, particularly in terms of community character and consistency with local plans. That is the town code, as discussed extensively in our report, and which I summarized previously. Overall, the impact evaluations form the technical basis for the issuance of a negative declaration for the proposed action, based on the absence of any potential significant adverse environmental impacts. The town, my understanding, the town has not determined the future use for the subject property if the proposed land acquisition is effectuated. Once a future use has been decided upon, the need for further review under SECRA will be evaluated, and as required, any necessary additional SECRA proceedings will have to be completed before action is undertaken for the new use, either whether the town undertakes a project approval, funding, or construction. They would have to evaluate whether further review under SECRA is required. And that concludes my testimony.
Ms. Diamond, anything further?
Yes, I just had one thing, Judge, and that is I wanted the board to be aware of a decision of the Appellate Division's Second Department in the matter of Rocky Point Realty, LLC versus the town of Brookhaven. It's cited at 36 Appellate Division 3rd, 708, and was decided by the Appellate Division 2nd Department in 2007. The reason that I wanted to make the town board aware of this decision, it contains some language that I think is relevant on the issue of public use. In the words of the court, I quote, "The term public use is broadly defined to encompass any use which contributes to the health, safety, general welfare, convenience, or prosperity of the community," which is exactly this case. And so, for purposes of the record, I simply wanted to make the board aware of that decision. Thank you very much. We have nothing further.
Thank you, Mr. Hyman. In behalf of the hotel, motel, the landlord, counsel. Good evening, counsel.
Good evening, Judge. It's Christian Brown, McLaughlin and Stern, 1122 Franklin Avenue, Garden City, representing the owner, L&S Realty Corp., LLC. Have a letter and a declaration I'll hand up, but I just have...
So let me ask you to begin by, is it correct that you're opposed to the condemnation?
Well,
would be fair to say.
Yeah, I mean, I would say this. A condemnation done legally for a valid public purpose is a condemnation done legally for a valid public purpose. And if the town were to take this property or any other property after it properly identifies a valid public purpose and pays fair market value for the property, it's perfectly entitled to do that. However, what we have heard tonight and in your notice, respectfully, is completely illegal and is the complete opposite of what the eminent domain proceeding law exists to do.
And would you tell us why?
I will. So let me just pick up where Mr. Hyman left off.
Sure.
He defined public use for you. That is the definition of public use. But before you can define public use, you have to define a use. You cannot say that you're going to take someone's private property because you don't like the people who operate it or you deem it to be a nuisance, you don't think it's a good use, to just take it away and then later on figure out what you're going to do with it, because by that circular reasoning, it's a bad use, so it will be in your judgment. So taking it away from a private person is a benefit to the public because you've ended what someone subjectively determines to be a bad use. And if I may, read from the matter of HBC Victor, LLC versus Town of Victor.
Could you give us the full citation if you have it?
Certainly. It's 212 AD 3rd, 121. 4th Department, 2022. Because the town has not indicated what it intends to do with the property, we are unable to determine whether the acquisition will serve a public use. Of course, the existence of a public use, benefit, or purpose underlying a condemnation is a sine qua non to the government's ability to exercise its powers to take private property through eminent domain. As our colleagues in the 2nd Department have noted, the existence of a public use must be determined at the time of the taking, in italics, since the requirement of a public use would otherwise be rendered meaningless by bringing speculative future public benefits which might never be realized within its scope. In simple terms, the government cannot take your land and then decide later what to do with it without running afoul of the takings clause of the 5th Amendment of the United States Constitution as applied to the states by the 14th Amendment. So the last statement that you just heard, we don't know what we want to do with it, but we want to get rid of it because we don't like it, is illegal. You cannot do that. Your notice does not state what you want to do with this property. Again, it just states we want to get rid of the motel because we don't think it's good for the public and we want to give it to somebody else to do something else with it at a later time. It's simply not proper. Now, this board has already determined in its judgment that the motel constitutes a public nuisance. We've had hearings on that. That determination is now in litigation in both the state and the federal court. And you've exercised your remedies under the nuisance provisions of your code. You've closed it down for 1 year, which the code allegedly, purportedly, we contest this, but the code gives this board the power to close it administratively for 1 year. And you have also brought an action in the Supreme Court seeking to close it down for a total of 3 years, which is another prerogative that's given to you under the nuisance chapter. You've exercised those prerogatives. You've closed the motel, and you're seeking to close it for a longer period in a Supreme Court action. That's nuisance. That's what you have the power ostensibly under your code to do. We're contesting that, but that is off the table. It has nothing to do with eminent domain. So you've exercised your remedies under the nuisance provision. The fact that you've deemed it a nuisance, even if it is a nuisance, doesn't empower you to take title to it, to give it to somebody else and not specify it. A public benefit is not taking it from someone you don't like and giving it to someone you do like because you think that next private owner will be better for the community. That's not a public purpose. Now, you're also proceeding under the eminent domain procedure law. You're not proceeding under the general municipal law where you can, in some instances, condemn blighted areas and so forth after you follow the procedures for doing that, which include a study determining that certain sections, pieces of land are in fact blighted. This is not a blighted property. It never was a blighted property. It was a going concern motel before the town came in and closed it. In fact, it's been there for over 40 years. Never had any code violations. It passed its inspection every year. It passed its inspection months prior to the town coming in and closing it down. It is not true to say that this motel was closed because of a dangerous building. That was something that was said after the fact, but the town board never held a dangerous building proceeding under Chapter, I believe it's Chapter 90, where evidence is presented to the town board about structural dangers and other types of, code deficiencies, and then the board adjudicates on the hearing of evidence, adjudicates a structure dangerous. That never happened here. The motel was closed without any process, and later the town said, oh, it's also dangerous. So there's never been an adjudication administratively under Chapter 90, and there has never been a single summons, criminal summons, adjudicated against this property owner. Not one single time. They have not been found guilty of a single code violation in the district court. So it is not accurate to just say, well, we went in there and we thought it was bad, we don't like it, there's a report that, no. To the extent that it's relevant, I'm just telling you, none of that has happened. This property, people don't like it, I understand that, but this property was a going concern business, lawfully operating in the business district, lawful use, just as good as a liquor store, just as good as a gas station, no tickets, no summonses, passes its public assembly inspection. That is not a blighted or derelict site. And therefore, and you're not proceeding under the law that would allow you to take it under those conditions. And you would be incumbent on the town to produce evidence and a study, a blight study, to show that the property is blighted and that would enable you to proceed under the general municipal law statutory scheme. None of that has even been invoked by the board, but I just think it's worth pointing out that no adjudication has ever been made against this property on those grounds. So basically, I respectfully, we have to object to this entire proceeding. Taking this property as a parking lot, for a park, for a recreation center, that's a valid public purpose. It would be a valid public purpose for the town to take any property for something like I just delineated. As long as that purpose is named in the notice and you follow the procedures, then the town has whatever rights it would have to take by eminent domain. But you cannot proceed in this way. You cannot proceed without identifying a public purpose, and a public purpose is not taking private property away from a disfavored owner and later on giving it to somebody else that you think is better, or later on identifying what might be a public purpose down the road. You have to tell us that now so the courts and the owner can evaluate whether, in fact, what you're doing is lawful and proper. And we can't do that at this point. So for those reasons, I have to object to everything that's gone on here tonight. I'm going to hand up our letter of objection, which has further case citations in it. I'm also going to hand up a declaration from Mr. Brooks, who is the manager of the property. You've heard from him before, heard about him before, and I'd ask you to consider those submissions, and I'd ask you to abandon this proceeding because it's not lawful, and if you intend to attempt to take it, to do it correctly and give us the proper notice and identify a public purpose.
I'm acknowledging receipt of the two documents.
Thank you.
Do you want them marked as one exhibit, or would you like them marked separately?
Probably better to mark them separately.
Okay, so the letter dated January 30th, 2024 will be the property owners A, and two pages. Second one is a two-page, signed by Sam Brooks, the document signed by
Saul Brooks.
I'm sorry, Saul Brooks. Lighting's a little bad in here. That'll be marked as Exhibit B for the the property owner.
And I just want to add one final point for the record.
Sure, of course.
As you know, a secret determination also has to be performed in connection with a proceeding such as this. I know you heard about the EAF, but again, what is that studying? That's just saying, well, it would be good if the motel weren't there. No, the EAF is supposed to study a proposed use. What would the effect of a proposed project be here? So you cannot make any kind of determination about effects on the environment and on the surrounding neighborhood until you know what would you use this property for. That's the whole purpose of the secret process. So again, without that basic foundation, it's just not proper to proceed any further here. The town can consider other ideas and do what it wishes when it can specify a public purpose, if it ever comes to that. But as of right now, I stand on my objections.
Okay. Do you have anyone else you'd like to present?
No, there's no one else here tonight.
Thank you, counsel.
You're welcome. Thank you.
Is there anyone else here who opposes the application, the position that counsel has just taken? If so, would you please stand up and, okay. Anyone else? Would you like to be heard, sir?
Respectfully, Your Honor, we have a list, and I'll call a list, and Mr. Picacci is on that list.
Oh, okay.
So can I call some speakers, Your Honor?
So what we'd like to do at this point is, if I may, is there anyone who is here who's in favor of the application and need not necessarily want to speak, but even if you do want to speak, could you please raise your hand if you're in favor of this application, just so we get a sense of how many people.
Yeah, in favor of what?
In favor of.
Yeah, that you are not opposed to it, but you are agreeing with the request for the condemnation of the property. That you agree with that it should be condemned. Okay. Just. Yes, that's. What's that play? Okay. Thank you. That's the approximately 25 people or so, 30 people, most of the audience. So anyone from the general public who would like to be heard, we now will impose the 3-minute time limit with respect to everyone. And don't be concerned if you don't have a watch. We have actually a little clock right in front of me that's going to help you and assist you in understanding when you get to 3 minutes. And by the way, you don't have to use the entire 3 minutes. You could make your views known in less than 3 minutes if you'd like. So I'm going to ask the town attorney at this time to call, and let's start with, if you would, I'd like to hear from the individuals who are, in effect, opposed to the application.
Judge, I'm not familiar with all of them because we have a list where we don't indicate whether they're in favor or opposed, but I know that Mr. Picacci is against it, so why don't we call him first?
Sure.
Felix Procacci, Franklin Square. The resolutions for this hearing say in part, the town board has taken testimony and the Capri Motel is unfit for human habitation. In response to my FOIL request for that testimony, the town indicated there are no responsive documents. In response to my FOIL request for complaints, I received a 6-page building department report which did not indicate the Capri Motel is unfit for human habitation. In response to my request for police responses, the town provided me a report containing 194 incidents regarding police activity at the Capri Motel, not 597 as indicated at the previous nuisance hearing. In analyzing the data that was provided, the number one reason of a police response was characterized as aided. This occurred 79 times. The next 5 most frequent reasons were controlled substance at 20, suspicious incident at 16, field interview at 14, domestic incident at 9, and criminal mischief at 6. Although prostitution is specifically mentioned in the resolution, the police reports provided only one incident as mentioned at the... The police reports only provided only one incident, and as mentioned at the public nuisance hearing on September 6th, this person was a police officer posing as a prostitute. The town claims it took testimony, but provided no evidence of this testimony. The town claims the Capri Motel is unfit for human habitation, but its own building department, at least twice in 2023, did not find that the Capri Motel is unfit for human habitation. At this point, the right thing to do is dismiss this resolution and close the hearing. The town's resolution clearly is an error. There is no testimony, there is no evidence the Capri Motel is unfit for human habitation. In addition, the town did not follow Open Meetings Law, Section 103E, which requires the documents that the town board received to give to the residents prior to the meeting. 24 hours prior to hearing, they should have been posted online. That was not done. So that's fatal on this. Also, this condemnation, this nuisance thing, it didn't cure anything. It moved residents who may have had mental issues, drug addiction issues, social problems, whatever it is, and they moved them to a different location. It didn't solve any problems except give the problem to somebody else. Thank you very much.
Thank you.
For the general public, and Mr. Picacci knows it, we take general public comment from the microphone up where Commissioner Martelli is. So in the future, anybody that I call, please go up to Commissioner Martelli. This microphone is. At this time, I'd like to call legislator John Giuffre.
You feel better. Feel better.
Judge Morano, Deputy Supervisor, members of the town board, something has to be done. And on behalf of the constituents in the 8th Legislative District whom I represent, and also Legislator Gaylor, who couldn't be here tonight, we speak in favor of this condemnation proceeding. There have been hundreds of police calls, whether it's 597 or 197 in a short period of time. And the constituents that we represent welcome the town action to condemn this property and take it by eminent domain. So thank you.
Maureen Greenberg.
Thank you.
Good evening. Maureen Greenberg, West Hempstead. I'm the president of the West Hempstead Community Support Association, and I want to thank Deputy Supervisor Gooseby, and the Town Board for this evening's meeting. The Executive Board of the West Hempstead Community Support Association and the residents I have continually corresponded with since August, when the Capri Motel was closed for nuisance, want to see this establishment shut forever. They do, however, have some questions. What will go there? Who will pay the taxes? Will immigrants or homeless be placed there? These are questions that need to be answered to the community. The board has voted again unanimously that the blight on the community should be taken over by eminent domain. I handed in over 800 petitions in August from the residents that wanted to see this establishment shut for good. The makeup of West Hempstead community has not changed since August. 2 blocks away is the West Hempstead Union Free School District, George Washington, and less than half a mile the other way is the John Street School on Nassau Boulevard. There's a baseball field on Cherry Valley Avenue. Residents living around this establishment for years have put up with drugs and other illegal activities. The police report that was given in August showed over 500 calls to the Capri Motel. Since then, in August to the end of December, only 1 call has made. Yes, while the building has been shuttered, that leaves 500 calls less where Nassau County Police can maintain the rest of the community for other needs and their calls. Local businesses, Stop and Shop in particular, has put up with the issues of patrons of the motel causing issues in the store, as well as residents being approached in the parking lot and across the street. I've spoken personally to the Stop and Shop manager, who states business is better and the parking lot is a lot nicer to live with. The town saw fit to shut down, and now we must keep it shut forever. Deputy Supervisor Gooseby, last week through the Herald, an announcement was made that this meeting would happen, making a public notice that to the residents that the eminent domain was tonight's discussion. We ask you and the town board to do whatever it takes to keep this business shuttered and keep our residents safe. Thank you.
Thank you. Barbara Kelty? Thank you. Thomas Pittman?
Oh, good evening, and thank you. Thank you for this opportunity to speak. My family has lived here for 27 years. Our son went to school here from the 3rd grade through high school. He actually went to school with a Muscarella named Susanna. They both played in the band together. I appreciate all the services that the town provides, especially the music concerts and the recreational facilities like at Echo Park, where I learned Kundalini Yoga. There are 3 things that I want to present to everyone here for consideration. And listen to this with the idea of the spirit of the law rather than the letter of the law. The Capri, with its lengthy rap sheet of criminal activities, was using valuable police resources that now can be deployed elsewhere. And in its place, if we do build housing, let's build affordable housing, not more luxury units like 130 West and Heritage by Heatherwood that the average person can't afford, and they're not going to be taking the LIRR nearby. They're going to be taking the bus because of the high rents in those 2 places. Let's build affordable housing for families here on Long Island. And regarding the seizure of the Capri property under eminent domain, because that eminent domain principle, especially since Supreme Court decision Berman in 1954, it really has been loosely used and sometimes abused. So what I'm asking is that will the public have access to any hearings that are going to be held about the proposed use so that we can actually see what the town is planning so that it is in the public interest? And that's probably all I want to just say is, will the public hearings be held so that we can actually be part of it? You know, we're the community that you serve, so we'd like to be part of whatever conversations go on about how that land will be used. Thank you.
Thank you. Aaron Kopowitz. Your Honor, I don't have anyone else signed in, but that doesn't mean that there might be some other speakers. Is there anyone who would like to address the board? Sir?
What, would you please identify yourself? Thank you.
Very much impressed with this whole setup. I appreciate all these jobs. But as I'm sitting here, I'm starting to say to myself, why would somebody fight so hard to keep a hotel up that possibly has no street traffic to stay there? So here's what I come up with. This can be rented out. And people may not like what I'm going to say to illegal immigrants. There's nothing in your laws, unless you correct me, that says you can't do that. That would be no better than what it was doing before. I can't understand why somebody would spend so much money on legal fees, federal courts, Supreme Courts, for that. It doesn't make sense to me unless there's a more monetary explanation for it down the road. I would love to see something else for the children in that area there. Even though I know it's on Hempstead Turnpike, not the perfect there, but I'd like to see the children benefit by that. Thank you very much.
Anyone else wish to be heard? Sir, I would ask you to go to the microphone because I've just been reminded that we are live streaming this, so you can watch this from your home, and if you don't speak at the microphone, you won't be able to be viewed.
My name is Ralph DeBello, Garden City South. I want to thank Your Honor and the board for hearing us tonight. You know, we pay high taxes in the area. Among all the issues that were brought up tonight. Also, what it could be is immigration was a big issue, and the governor already placed him at Nassau County's doorstep in Creedmoor. And there's been reports of the homeowners that they've been seeing men in their yards at night, knocking on doors, asking for money, We don't want that happening around here. We pay enough taxes. We have a lot of nice areas. So come to a resolution, but we should keep the hotel closed down and consider something better. Thank you.
Thank you.
I would just indicate for the record that the town has received no indication that, with regard to migrants being placed at this site. First time it came up in our discussions is tonight by the last two speakers, so there's no indication whatsoever.
Sir, we
Understood.
hear you. Sir, please. Is there anyone else who'd like to be heard? Okay. So then that'll close this portion of the proceedings. And I'd like to thank everyone for their cooperation. And Deputy Supervisor Gooseby, there are a couple of recommendations that I'd like to make very specifically at this point in time. And so that, one, let me make it clear that there is not going to be a vote this evening. This was just an opportunity to be heard. And so my first recommendation is that you keep the record open until March 1st, 2024, and that would be to allow the public additional time to submit comments on this particular matter, number one. Number two, I would suggest that you allow me, as the hearing officer, until March 31st, 2024, to prepare a recommendation to the board on the use of eminent domain to acquire the parcel. And I would, after reviewing tonight's evidence, as well as any additional comments which may be received up until March 1st, 2024. Third, I would ask for this board to make and publish a determination of findings concerning the proposed public project for this property no later than May 28th, 2024, in accordance with the law of eminent domain and, of course, the eminent domain procedure law. And lastly, my suggestion is that a copy of the record of these proceedings be held at the office of the town attorney, as well as on the town attorney's website and in the office of the Nassau County Clerk, and all that is in accordance with the eminent domain procedure law, section 203. That completes, I think, the proceedings for this evening. And again, I want to thank the public, as well as, of course, all the board members for their participation and cooperation.
Thank you, Justice Marino, for your time and assistance this evening. May I have a motion as recommended by Justice Marino?
So moved.
I second the motion.
Madam Clerk, please call the roll.
Councilman Carini.
Aye.
Deputy Supervisor Gooseby.
Aye.
Councilwoman Miller.
Aye.
Councilman Muscarella.
Aye.
Councilwoman Ryder.
Aye.
Thanks to every one of you who came this evening. And for everyone's benefit, we will arrange for the evidence submitted tonight to be posted to the town's website for public viewing. May I have a motion to adjourn?
I make a motion to adjourn.
Second.
Councilman Carini.
Aye.
Deputy Supervisor Gooseby.
Aye.
Councilwoman Miller.
Aye.
Councilman Muscarella.
Aye.
Councilwoman Ryder.
Aye.
Good evening, everybody. Thank you for coming.
What?